Can you get a green card during or after deportation?
Hi, greetings to you. I am Attorney Edwin Fogam. Our question for today is whether you can obtain your green card after you have been placed in removal proceedings or while your case is pending on appeal at the level of the Board of Immigration Appeal, or after your appeal has been dismissed. The answer to this question is yes, depending on the circumstances. If your case is still pending before the immigration court and you have a relief, that is, you have a petition that you can pursue, yes, you can still obtain your green card. For example, if you have an approved I-130 petition filed based on marriage, or you have an approved I-140 based on employment, or a VAWA approved petition, Violence Against Women's Act, an approved I-360, or an SIJS Special Immigrant Juvenile Status Petition, an I-360 that has been approved, you can proceed to seek adjustment of status in proceedings, and you can actually obtain your green card at that level. Or alternatively, you can have the court terminate the removal proceedings and you seek adjustment of status with USCIS. What if your case is already before the Board of Immigration Appeals? You can still do that if you have a valid relief to seek. What you can do is request that your case be sent back to the immigration court and you seek adjustment of status at that level. It's called remand. You can ask for your case to be remanded back to be considered, and you can now seek these reliefs. What if your appeal has been dismissed? Even if your appeal has been dismissed, you can file a motion to reopen. Now, unfortunately, you have only 90 days to file that motion to reopen. However, there are some exceptions. If there are changed circumstances, or if you can have the government, DHS, join you in a motion, the Board of Immigration Appeals can still entertain that motion and reopen the proceedings for purposes of seeking your green card adjustment of status. Now, in very extreme circumstances or difficult situations when it's been very long, you can ask the board to exercise its own jurisdiction to reopen the case. It is called Sua Sponte. In other words, you are requesting that the judge or the board acts on its own to reopen your case. In this situation, you need to prove some very extreme or exceptional circumstances. I hope this information was helpful to you. If you have any questions or you would like us to review your situation, please feel free to call us. Our phone number is 301-608-1555. You can also email us on ekfogam@fogamlaw.com or info@fogamlaw.com. And always remember, don't fear the system. Understand it, work with it, and benefit from it. We can help you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.